The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Hi, I'm Kevin O'Flaherty. I hope you enjoyed this Learn About Law video and podcast presented by O'Flaherty Law. If you need some help, please feel free to give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have several locations for your convenience. Thank you so much for watching.
Today's video will define force majeure and discuss if this type of clause can really be enforced, how the language of the contract affects the force majeure clause, and how to prove or disprove the validity of this type of clause in a business contract. So as of recording this, uncertainty due to the COVID-19 pandemic still rules the world, causing business owners and clients alike to ask the question, can I get out of this obligation and cut my losses in order to weather the storm? So from large corporations to mom and pop shops, attorneys will be combing through contracts for months as the economic fallout of the coronavirus continues. So what exactly is force majeure? Well, Cornell Law School defines force majeure as a provision commonly found in contracts that frees both parties from obligation if an extraordinary event prevents one or both parties from performing. These events must be unforeseeable and
Hi,
unavoidable.
Kevin O'Flaherty again. Hope you enjoyed that presentation of Learn About Law presented by O'Flaherty Law. If you need some help, please give us a call, 563-503-6910, 563-503-6910. Again, we offer free consultations in many areas of law, and we have several geographic locations for your convenience. If you found this helpful, we'd love it if you'd subscribe to us on YouTube, SoundCloud, Apple Podcasts, or wherever you listen to your podcasts or watch your videos. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.
External of both parties and not the result of either party's actions, intentional or otherwise. Number two, the event radically changes the ability of the affected party to fulfill its contractual obligations. Number three, the force majeure event was unpredictable. And number four, the event must be completely outside the influence of the party seeking relief under the clause. So let's talk a little bit about contract language, right? So many contracts contain generalized language under their force majeure clause, stating that the excuse of performance obligations and relief from the contract should only be feasible if it is impossible to complete the obligations listed in the contract. Proving something is impossible sets a very high bar, obviously. A more realistic wording might be excusing performance when there is a clear or physical psychological risk, or it would be illegal, or commercially impracticable and impossible. Furthermore, using language that contains specific words such as emergencies that come after a comma within the same grouping would cause the entire list of items to be judged under that one word or description. For example, using the words "or any other emergency" after a comma at the end of the sentence leaves room for arguing that the situation was not necessarily an emergency and should not be covered under the clause. Relief under a force majeure clause is not always guaranteed. Below is going to be a handful of prominent factors courts consider when awarding or denying relief in a force majeure case. So you've got burden of proof, you've got contract, scope, and interpretation, you've got causation, and causation mainly refers to the affected party being required to prove that the force majeure event was solely to blame for the inability to perform under the contract and not some other issue or semi-related issue. Again, the language will have some bearing on proving causation. Obviously, there's also deadlines and notification. The affected party is required to notify its counterparty of the force majeure event and resultant inability to satisfy the contractual obligations. This deadline differs from state to state and from contract to contract. So how do you move forward through all this? Well, if you feel that you have a legitimate claim, seeking out the guidance of a qualified attorney is going to be a good first step. Due to the complexity and interpretation of force majeure clauses, it is likely that some form of legal intervention will play out. And if you have any questions, please don't hesitate to call us at 630-324-6666. As always, thank you for tuning in.
Hi, Kevin O'Flaherty again from O'Flaherty Law. Hope you enjoyed our presentation of Learn About Law. If you need some help, please feel free to give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have several geographic locations for your convenience. If you found this helpful, we'd love it if you'd subscribe to us on YouTube, SoundCloud, Apple Podcasts, or wherever you listen to your podcasts or watch your videos. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.